Hey everyone, James Reeves, Esquire. I'm not your lawyer. This is not legal advice. The Fourth Circuit Court of Appeals just upheld Maryland's assault weapons ban in the Bianchi v. Bruen case, and unfortunately, the argument could be technically correct based upon weak language from the Supreme Court about the Second Amendment in recent history. This is a follow-up to my previous video, why the Second Amendment doesn't protect the AR-15. In that video, I discuss how the courts ignored the question of whether or not the AR-15 is entitled to Second Amendment protection. The Supreme Court justices, being a bunch of Supreme Court jussies when it comes to the AR-15, they haven't addressed it at all. If any firearm deserves Second Amendment protection, it's the AR-15, arguably the select fire variant, the M16, more so than any other class of firearm protected by the Second Amendment, such as handguns, contrary to the implications of Bruen, which we'll talk about in just a sec. The decision in this case, Bianchi, argued back in March, decided on August 6, highlights the precise issue I discussed in that last video. Although the opinion in Bianchi is nearly 200 pages long, it's an excellent recap of the present status of what the Second Amendment does and does not protect in a post-Bruen world, as well as what questions remain unresolved, specifically what protection the AR-15 is entitled to. I highly recommend reading the opinion from Bianchi if you have the time. Will this finally be the case that the Supreme Court will take up to resolve where the AR-15 belongs in the context of the Second Amendment once and for all? They haven't so far. The Supreme Court's had multiple opportunities to take up the AR-15 issue in the past. 3 recent cases, including Friedman v. City of Highland Park, Warman v. Healy, and Colby v. Hogan, all decided between 2015 and 2019, were final decisions upholding assault weapons bans. In other words, these cases were ripe for adjudication, but the Supreme Court decided not to hear them, allowing those assault weapons bans to stay in place. I mention that because some of the comments of the last video, people are like, James, well, you're talking about interlocutory appeals where the court didn't have to hear them. Well, there's at least 3 cases upholding assault weapons bans that were final judgments that the Supreme Court said, nah, we're good. Keep your assault weapons ban. But the game done changed since 2019. 1, the Supreme Court has a clear conservative majority. 2, as a consequence, perhaps, of that conservative court makeup, we have the Bruen decision. Bruen overturned New York State's requirement that applicants show proper cause for having a handgun for personal protection, but that decision was narrowly tailored only to address handguns. Some of the language from Bruen is responsible, in fact, for the exact predicament we find ourselves in today with the AR-15 and the Second Amendment and Bianchi. Thus, technically speaking, the Bianchi decision isn't incorrect because of how it interpreted the Supreme Court's inconsistent approach to the AR-15 in the past. Bruen imposed a very rational test that requires lower courts to look at the historical tradition of firearms regulation to determine whether a particular restriction on gun ownership is permissible under the Second Amendment. And I think that's a great approach too, because after all, a lot's changed in the past 250 years, but the spirit and the purpose of the Second Amendment have not. Thus, this test is perhaps the best means, I would say, of trying to determine what the framers of the Constitution would have us do as we sit here today. Now, before we get started, I'm not wading into politics here. I don't do politics on this channel. You guys know that. This is my personal interpretation of the law as a lawyer. What I mentioned in the last video, it's quite clear in the historical context of the Second Amendment that the Founding Fathers wanted to ensure the free people of the United States would never be subjugated by a government against their will. They wanted to make sure the right of the people to keep and bear arms would not be infringed. What arms would they possibly be talking about? Many of the most capable American Revolutionary War fighters were using the Kentucky long rifle, a state-of-the-art infantry rifle at the time, which is more accurate, more effective at a longer range than smoothbore muskets like the Brown Bess used by the British. Thus, it stands to reason that the Founding Fathers, if you're looking at it historically, wanted to ensure that we, the people, had a right to, if anything, a shoulder-fired, conventional long gun used by the infantry. In modern terms, that's the M16, maybe the AR-15. The dissent in Bianchi does a good job of emphasizing this point with some historical evidence, so have a look at that if you have the time. What's funny to me is decisions like Heller and Bruen emphasize individual personal defense and handguns, and they say handguns fall squarely within the Second Amendment. The British are coming, let me grab my bracer of pistols and the derringer that my mistress keeps in her corset. That's silly. We're not talking Orlando Bloom from Pirates of the Caribbean. We're talking Mel Gibson in The fucking Patriot. Hell, if you want to argue with me that handguns aren't protected by the Second Amendment, or that you have to be part of a militia to be protected by the Second Amendment, or that cannons, artillery, tanks, tactical nukes are not part of the Second Amendment, any of those arguments make more logical sense than saying the AR-15 is not protected by the Second Amendment, historically speaking, which is the test we're looking at from Bruen today. As I emphasized over and over again in the last video, if you think people shouldn't be able to own AR-15s, then just say you want the Second Amendment deleted. That's the correct counter-argument we should be focusing on, whether or not we still need the Second Amendment, not some convoluted torturing of history and a pretty clear command of shall not be infringed to infer that the one and only gun, perhaps 100% clearly within the ambit of the Second Amendment, somehow isn't. But that's where we are because of these lukewarm Supreme Court decisions and these refusals to hear cases relative to assault weapons bans and the AR-15. Let me explain. At the very opening of the Bianchi majority opinion, the Fourth Circuit says the AR-15 isn't protected by the Second Amendment because it is a military-style weapon designed for sustained combat operations. This is all a quote. Not for self-defense, and they pose a danger to the police, i.e. the government. Again, I think the clear interpretation of the Second Amendment historically is exactly that. The people should have access to military-style weapons designed for sustained combat operations like the Revolutionary War, perhaps. Now, some people out there say that the Founding Fathers, they could not have anticipated these advances in firearm technology or the AR-15. So you're telling me the Founding Fathers, in the presence of renowned drunkard inventor Benjamin fucking Franklin, meant to include only muskets and black powder rifles as part of the Second Amendment. Do you think the framers of the Constitution, who saw firearms technology advance before their very eyes, going from muskets to rifles during the Revolutionary War, they would have never contemplated that technology for firearms would continue to advance? Now, the Supreme Court in Heller has said verbatim, I mean, this argument's done. They said this argument borders on frivolous, and that's a quote. In Caetano versus Massachusetts, the court flat out held the Second Amendment extends to arms not in existence at the time of founding and may protect arms beyond weapons useful in warfare. In other words, the Supreme Court hasn't flat out said the AR-15 is protected by the Second Amendment, but they have implied that modern day military weapons could be protected by the Second Amendment. The Fourth Circuit actually acknowledges this, in their opinion, but instead of saying that technological advancement couldn't have been contemplated by our forefathers, they say that the present state of society couldn't have been anticipated. These aren't our forebears' arms. These are not our forebears' calamities, the majority writes, pointing to what they call unprecedented societal concerns, i.e. mass shootings. According to the majority, it wasn't until 1949, almost 2 centuries after the Constitution, that the first shooting claiming double-digit lives took place in the U.S. That all said, the dissent in Bianchi makes the counterpoint. They mention that the Supreme Court has already refused to throw aside the constitutional liberties of millions of people to prevent the unlawful actions of the few criminals. Handguns, quite dangerous. In fact, handguns are responsible for 60 to 70% of the firearm deaths in the U.S. versus 3 to 4% for assault rifles. But Bruen specifically protected handguns anyways because the rights of millions of law-abiding citizens shouldn't be tread underfoot just because of a few criminals. This philosophy could perhaps be summarized best by Benjamin Franklin himself. Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. You guys have heard that 100 times. Obviously, reasonable minds can differ on the subject of whether or not people should be able to own an AR-15, but I say again, if you feel like Americans shouldn't be able to have AR-15s, then just say you want to abolish the Second Amendment. Let's focus on debating that issue, which would be more constructive, instead of trying to reconcile a ban on the AR-15 within the scope of the historical context of the Second Amendment. It doesn't make sense. The Bianchi court also says the assault weapons ban fits within the historical tradition of firearms regulation because assault weapons bans regulate excessively dangerous weapons. This is another consequence of weak analysis in Bruen and Heller. You may have been too busy cheering about the win in Heller to overlook the fact that the court said, in that opinion, It's startling to suggest that the ban on the M16 specifically might be unconstitutional. In other words, the Supreme Court's already said almost explicitly that the M16 is not protected by the Second Amendment. The Fourth Circuit also discussed U.S. v. Miller, which is a case from 1939 that said the Second Amendment doesn't protect dangerous and unusual weapons not in common use. In the three recent Supreme Court cases that I would otherwise call the triad of victory, Bruen, McDonald, and Heller, they all emphasize that the central component, quote, of the Second Amendment is individual self-defense. The Fourth Circuit emphasizes this as well, this central component language. Why? Because they're pitching the Second Amendment as not the collective right to protect oneself against a tyrannical government, which might support owning an AR-15. And that was clearly what was fresh on the framers' minds when they drafted the Second Amendment. Rather, the Fourth Circuit wants to say that an individual right to self-defense, that's the handgun. Basically, according to the majority, not the AR-15. They argue that guns typically used by the average citizen for self-defense fall within the Second Amendment, but guns that empower individuals, this is their words, empower individuals to single-handedly rain terror upon a community are dangerous and unusual under Heller, and therefore they can be banned without infringing the Second Amendment. There's your problem with Heller and with Bruen. It's vague enough to allow the Fourth Circuit to persuasively argue that the AR-15 isn't required for individual self-defense. After all, it was Bruen that said the central component of the Second Amendment is individual self-defense. The Bianchi dissent argued that there isn't simply a right to just individual self-defense in the Second Amendment, but also collective self-defense. The Fourth Circuit majority repeatedly emphasizes, though, this individual right to self-defense as the quote-unquote central component of the Second Amendment to justify a ban on the AR-15. To say the central component of the Second Amendment is individual self-defense doesn't mean that collective defense of the free people isn't also protected by the Second Amendment, but Bruen's emphasis on the individual right of self-defense permits exactly the conclusion made by the majority in Bianchi. The Bianchi dissent, they say there's no support for the majority's assertion that dangerous weapons not protected by the Second Amendment would include military weapons because history and tradition establish the exact opposite. To my exact point from the last video, the dissent in Bianchi says that citizens commonly possessed weapons useful for self-defense and militia service. I quote, weapons used by militiamen and weapons used in defense of person and home were one and the same, as a militia would be useless unless the citizens were able to exercise themselves in the use of warlike weapons. Some general knowledge of arms is important to public welfare because it would be impossible in case of war to organize promptly an efficient force of volunteers unless the people had some familiarity with weapons of war. Again, my exact point, the AR-15, the M16, those are the guns protected by the Second Amendment. An annoying aspect, by the way, of this majority opinion in Bianchi, probably a bunch of crusty old dudes who have never handled an AR-15 in their lives lecture me about over-penetration and how unsuitable AR-15s are for home defense and self-defense. This is all incorrect, I might add. And they get into the technical and tactical aspects of the AR-15 with no knowledge whatsoever, just parroting, believe it or not, a tweet from a U.S. Navy SEAL, one tweet from a U.S. Navy SEAL, and some language that they probably found in a brief that they liked. Copy, paste. But the majority can do this because they're latching onto this ambiguity from Bruen. Some of you may remember a recent dissenting opinion from Justice Sotomayor in Bruen, where she described AR-15s as incredibly common. Now, pro-gun lawyers are jumping in the air, high-fiving each other, saying, see? Sotomayor herself, she said that AR-15s are in common use. And under Bruen, if a gun's in common use, protected by the Second Amendment. Not exactly. The Bianchi majority exploits vague language in Bruen, saying that a gun not in common use will not be protected by the Second Amendment, but just because a gun is in common use doesn't necessarily mean it's protected by the Second Amendment. In other words, it's a necessary, not a sufficient condition. The majority opinion says that Bruen implies the weapon needs more than just commonality. It must be common for self-defense by the average person. They claim that the appellants didn't prove that the AR-15 was in common use for self-defense by the average American. So where are we now with the Supreme Court? Well, the M16, definitely not protected, according to them. Weapons useful in warfare, maybe protected. Handguns, definitely protected. The AR-15, who knows? We've never gotten a straight answer. The Supreme Court has rejected every prior opportunity that it's had to address this issue head on, maybe Bianchi will finally give us some clarity. Thanks for watching. I'm not your lawyer. This is not legal advice. See you, everyone.